All right. Well, good afternoon, everyone. I'm Tatyana Bolton, the Cybersecurity Policy Director for the R Street Institute for Cybersecurity and Emerging Threats. Welcome to our Data Privacy Day event, which is part of our joint project with the Harvard Belfer Center's Cybersecurity Project, led by Lauren Zabierek, and Resolute Strategic Services, led by Cory Simpson. R Street is a nonprofit, nonpartisan public policy research organization. Our mission is to engage in policy research and outreach to promote free markets and limited effective government. We're dedicated to building broad coalitions and working with a wide array of groups who share specific policy goals, which makes us uniquely capable of building support for pragmatic free market proposals that can earn bipartisan consensus. Furthermore, the Cybersecurity and Emerging Threats program serves as the locus for R Street's work on cybersecurity threats to national, state, and private sector entities, the international balance of powers, military strategy, and other emerging national security issues. We're excited to host today's event in recognition of such an important topic in our world today, data security and data privacy. I'm looking forward to our keynote speakers and panelists exploring this critical and very timely area. So I will take a leap of faith to say that if you're watching today, we don't have to convince you of the need for federal data security and data privacy legislation. More likely, the reason you're here is to delve deeper and to hear a discussion on how to build on progress that we've already seen and shape a much needed privacy law. That's the approach we plan to take today. There have been many important publications and conversations on how we need federal legislation, from the consumer and industry perspectives to the national security standpoint, which we discussed at length this summer in our white paper, Congress Needs to Start Caring About Our Privacy as Much as China Does. At this point, the costs of continuing without a data privacy and security law are evident. It's bad for both consumers and businesses. And one aspect that has been less prominent in this debate is the cost to our national security. Our lack of a robust national data security framework makes us vulnerable to malicious actors, non-state and otherwise. At the same time, we're behind internationally, with major international players having already adopted and implemented national security and privacy legislation. And as you'll see, a number of our keynote speakers absolutely agree with this point of view. This is why we believe that data privacy and security are interlinked. You cannot simply have one without the other. You can't ensure users' data privacy if cybersecurity is lacking. But even with hardened networks, good security policies and consistent breach reporting, which is still mired on the hill, an unfounded data security privacy strategy still leaves users uncertain of their rights with their personal information and data. A national robust data framework would both increase security and be privacy enhancing. However, there are still significant factors at play. Legislation has stalled every single time over the course of the last 20 years when it's been introduced, and there are still several areas of disagreement. This makes it easy to view legislation as a lost cause or an academic debate. However, the necessity and the benefit of passing legislation requires moving the debate forward and finding areas of consensus. And that's why we need to ask two questions. What is different this time around? And how can we build on that in a bipartisan way using pragmatic solutions? So with these questions, I'm excited to transition to our exciting keynotes from two individuals who are dealing with this legislation firsthand. First, I'm honored to introduce Senator Ron Wyden from Oregon to talk to us about his perspective on data privacy and security.
Big thanks to R Street for giving me a chance to talk a little bit about data privacy. There is no question in my mind that data privacy legislation needs to be at the top of the congressional to-do list on tech policy. Now, there's a lot of disagreement between Democrats and Republicans about the future of the internet. Should companies take down more objectionable content? Should they be forced to host everything? There is, however, one key area of agreement. That's the need to give consumers more control over how companies collect, share, and use private data. Every other week, Americans learn about another privacy disaster. Each time, there's a company apology promises to do better. Like clockwork, it happens again within a few weeks. The Federal Trade Commission doesn't have the power or resources to stop these companies from misusing Americans' data. Even when the Federal Trade Commission investigated Facebook's rampant privacy abuses, it let Facebook off with a fine that was the dollar equivalent of a mosquito bite. A slap on the wrist will not protect Americans' privacy. That's why I authored the Mind Your Own Business Act that sets tough privacy and cybersecurity standards for companies that collect private data and gives the Federal Trade Commission the power, real power, so they have teeth to ensure serious fines to companies when they violate the rules, backed up with the possibility of jail time for the CEOs that are actually lying to the government. Democrats are aligned on the need for better consumer protection. That's why Senator Cantwell, Senator Brown, Representative Eshoo, all have proposed tough, comprehensive privacy bills. Now, this isn't, by the way, just a consumer protection issue. This is national security business. Just look at the vast troves of data that China stole from Anthem, Marriott, and Equifax, because these companies just weren't doing a good job securing Americans' private information. So soon, I'll introduce legislation to address the security issues proposed by the sale and export of sensitive private data to high-risk foreign countries. Big thanks to R Street for working closely with us on this, and hopefully we'll have a bipartisan co-sponsor to announce soon. One of the big issues raised from my first privacy bill was, what about foreign companies? What about foreign governments? What protections do Americans have there? I looked into the issue and found that there are currently no legal restrictions whatsoever against selling Americans' personal data to foreign companies and governments. Now, we know that there are huge troves of personal information about Americans, including records of cell phone locations, credit card purchases, and web browsing. They're all available for purchase on the open market to both foreign and domestic buyers. It's not hard to imagine how tracking where somebody goes or knowing what sites they visit online can create national security risks. Just last year, the Wall Street Journal demonstrated that US troops could be tracked using location data sold by data brokers. In April 21, the Director of National Intelligence, Avril Haines, warned, and I quote, "There's a concern about foreign adversaries getting commercially acquired information as well, and I'm absolutely committed to trying to do everything we can to reduce that possibility," unquote. So, the legislation that I'm going to advance will ask the Commerce Department to identify categories of sensitive information, as well as a list of high-risk countries where data exports ought to be controlled. The idea is to create an alliance of nations with privacy protective practices and keep Americans' data away from governments like China and Russia, where there is a good possibility it'll be used to harm American interests. So, we'll also mention today that there are two concrete proposals for doing something right now to protect Americans' interests, and they have nothing to do with restricting free speech or undermining the First Amendment or Section 230. I'm urging my colleagues in the Congress to use the current energy around regulating, having better oversight over the tech sector, and pass strong legislation that is going to help Americans secure their privacy and their security. And I'm hoping that thoughtful folks will join me to get something done, because we should not sit around and miss our chance. Thanks again for having me, and thanks for all that you do to produce solid privacy policy and for hosting this very helpful program.
Well, we so appreciate the attention Senator Wyden has placed on privacy and security. And now I'm very excited to introduce Senator Marsha Blackburn from Tennessee to hear about her perspective on data privacy and security.
Hi, everybody. I am U.S. Senator Marsha Blackburn, and just so pleased to join you today and talk a little bit about data privacy. And if you're watching this seminar, you know that we have had a long history of debate in both houses of Congress over this issue, not only this year, but going back several years. The issues that we have been discussing in our task forces and working groups and in hearings are now making their way into the mainstream. And I talk to Tennesseans every single day that say it is time to do something about online privacy. And the tech landscape and how it's changing has really affected children. And that has been really kind of top of mind, not only for policymakers like me, but for a whole lot of parents and grandparents, and I will say also pediatricians and teachers, as they have watched what has happened during COVID, during the lockdowns and the mandates that really have forced so many students, far too many students, out of the classroom. Parents are very concerned about the screen time and also what children are being exposed to during that screen time. They don't have the policy expertise for the most part because they have the parenting expertise. And what they do know is that privacy is a serious issue. It is a safety and security issue for them as they look at how to keep their children safe. And while it is always beneficial to look at these problems as they relate to all ages and all demographics, focusing on the issue of kids in tech has given those of us working on data privacy a good idea of how companies are approaching or not approaching this problem. As ranking member of the Consumer Protection Subcommittee, I've spent a lot of time with Chairman Blumenthal working on the issue. And over the past year, we've had multiple hearings. I'm sure many of you have watched those hearings on how underage users are used, and I would say abused, their data abused by big tech. What we've discovered in almost every case is that what we consider basic protections for users take a back seat to the value and the marketability of the data and the data trail that those users leave when they are online. Tech companies have made it clear that their business model depends upon the ability to collect and to repurpose that data. Most people have no problem with this. What they don't like is when these companies hide the ball and in some cases go against their own terms of use. People put a lot of trust in these platforms, and they need to know that their trust is not being abused and misplaced. We now have a mountain of evidence on the committee record that shows consumer data, especially data belonging to children, is being used in ways in which the users did not consent. So we've fielded a lot of pushback on this. The only way we'll get past this defensive posture is to commit to a clear path forward that has buy-in from tech companies and policy experts. We made good progress with this during the Judiciary Committee's Tech Task Force roundtables, and I have no reason to think that we are not going to be able to reach agreement this year. I look forward to the momentum continuing to grow and committee reaching agreement on privacy, data security, and children's privacy. The states have been responsive to the need for more privacy oversight, but if we're not careful, we'll end up with a patchwork of state regulations. The downside to this is twofold. First, not having a consistent standard will cause confusion. And second, every jurisdiction is going to have varying levels of sophistication and expertise behind their policies. This is why we're pushing for a national data privacy standard that will work not just for the mega companies like Google and Meta, but also for small businesses. And I think it's clear that we're not going to unring the bell when it comes to online commerce. If we follow through on our promises to actually close the digital divide and bring the entire country online with high-speed internet, we're going to operate and create an entire demographic of smaller businesses that will collect data as part of every transaction that they process. This means we have to have very clear, well-defined guidelines that Congress puts in place. Also, I will add to that, we don't want a lot of strict mandates that are going to hamper innovation. We need to allow the market to function without worrying about complicated compliance schemes that only the wealthiest and most sophisticated companies will be able to navigate. As usual, I want to leave you with the caveat that members of Congress are not the experts here, but that's no longer an excuse to do nothing. It's not going to be congressional subpoenas that bring tech companies to the table. Their customers are the ones who are forcing this issue. And I look forward to working with you and with a lot of Tennesseans and others that are interested in this issue, and businesses large and small, to solve these issues. Thank you so much.
Great. It's so fantastic to see members of Congress paying close attention to the privacy and security debate. Our street and myself sincerely appreciate and thank Senator Blackburn and Senator Wyden for participating today and for their continued work in the Senate. Now I'd like to introduce my partners on this project, Cory Simpson, Executive Vice President at Resolute Strategic Services, and Lauren Zabierek, Executive Director at the Cybersecurity Project at Harvard's Belfer Center, to talk about how we've structured our work and some of the contours of our recommendations. First, I'll pass it over to Cory Simpson.
Thank you, Tatyana. It's great to be with you today, and thank you to R Street for hosting this event, to our panelists for joining us, and also for the time and counsel on helping develop our thinking and our work products. Thank you to Senators Wyden and Blackburn for sharing their time and insights into these critical issues and ensuring congressional attention stays on them as well. I'm Cory Simpson. I'm an Executive Vice President at Resolute Strategic Services and formerly a Senior Director and Advisor to the U.S. Cyberspace Solarium Commission. Before digging into the process and methodology of our work, I'd like to highlight just a few points about the environment which our work is occurring, and expand on Tatyana's opening remarks and those of Senators Wyden and Blackburn. I believe this will help add a little context onto why this is so important. But again, I believe if you're listening in today, it's not a hard sell. Today, our economic, political, and national security spaces are converging, and they're doing so in a period of renewed great power competition. And at the center of all of this is data and questions around its security and privacy. In May of 2020, it was noted that as much as 90% of the world's data was created in the last 2 years. Since then, developments like cheap data storage, rapid maturing artificial intelligence, and machine learning have accelerated humankind's ability to derive value from this vast new data pool. As a result, our ability to generate, collect, analyze, and monetize data is surpassing our ability to consider the consequences such advances hold for our economy, privacy, or even national security. The implications are profound and highlight a desperate need for a cohesive and holistic national data security and privacy law. With this understanding, our group sought to convene, drive forward federal data security and privacy legislation. Fortunately for us, it wasn't hard to identify the main issues impeding progress. We found three. Two involve questions of enforcement of federal law, one being whether individuals should be empowered with a private right of action under the federal law, the other being a question as to what role the FTC should play in enforcing the federal statute. The third area in which our work focused involves the relationship between the federal law and existing and rapidly emerging state laws. Stated differently, to what degree federal law should preempt state law. To delve deeper into these questions, our group met with various stakeholders, including industry leaders, consumer and advocacy groups, and different levels and parts of government. Our conversations yielded a wealth of information that we have combined with our group's research and towards our end goal, which is to synthesize both stakeholder input and research into recommendations for effective, durable legislation framed in a bipartisan and accessible way. Important to our conversations, and we heard arguments for and against this specific proposal or that specific proposal, and we continue to encourage critical feedback on our work as we move forward. We know that any proposed solution cannot become a reality without capturing the perspective of multiple stakeholders and best addressing their concerns. So far, our findings show a path forward for progress and next steps, which we think is a pretty big deal. We are grateful for the years of research and hard work that has helped move the conversation on from an all or nothing approach to these issues to a more nuanced, one that has opened new perspectives, and it's shown in our engagement with stakeholders. Certain trends towards compromise continue to emerge, mostly united by a desire to finally have federal legislation and also in a willingness to come to the negotiating table on key issues like preemption, a private right of action, and the role of the FTC. I end where I began. It's great to be with you. I remain grateful to all that have contributed to the effort that allows us to be standing so close to realizing a cohesive and holistic national data security and privacy law that protects our data and better ensures our privacy. And with that, I turn it over to Lauren Zabierek to talk a little bit about our findings and recommendations.
Thank you so much, Cory, and thank you to Tatyana Bolton, and especially huge thanks to Senators Wyden and Blackburn, and of course to our panel of experts coming up next. My name is Lauren Zabierek, as Cory mentioned. I am the Executive Director of the Cyber Project at the Harvard Kennedy School's Belfer Center. I come to this role after a number of years in the intelligence community with a number of deployments under my belt. So I definitely, really come to this line of thinking from the national security perspective and, really wanting to protect our citizens and the people who live here. So I'll go into, some of our findings and recommendations here. All of our work and all of our discussions with people have really helped to shape our recommendations on the key issues that we mentioned: private right of action, preemption, and the role of the FTC. Although our research is still ongoing, I do want to share our preliminary and broad recommendations. Our final work will identify a range of options for resolving these issues with specific recommendations, along with looking at other issues like civil rights and privacy for children. So to begin, a federal data privacy and security law needs a specific definition of what entities and what data it covers, considering and addressing the impacts on all entities, including small businesses. This also aligns with the requirements for a critical part of the debate, a private right of action. Our research has shown that a private right of action is an avenue for negotiations between stakeholders. This also means it has some of the highest stakes, which means that getting the balance right on this is really important. So what does this balance look like? A private right of action should balance curbing frivolous lawsuits with protecting consumer data and offering an enforcement mechanism as the end goals. A private right of action should include different types of remedies, such as injunctive relief instead of monetary awards in some cases, reserving the monetary awards for a smaller category of violations and limiting damages. This combination of guardrails, while certainly not exhaustive, will help enforce national data privacy and security legislation and focus on the main goal of that legislation, which is to create a safer ecosystem where consumer privacy and data security is taken seriously. But private right of action is only a small auxiliary part of the enforcement. Primary enforcement of the national data security and privacy would rest in the Federal Trade Commission. But as we know, the FTC's authority to make rules is also subject to lots of discussion. So to start, we agree that the Commission is ill-equipped right now to enforce a privacy law successfully. So while we're still hashing out the exact figures, creating a dedicated bureau for enforcement with increased staffing and funding is part of this resource building. Indeed, federal privacy legislation should grant the FTC targeted rulemaking authority under the Administrative Procedure Act. Targeted rulemaking under the Act would allow Congress to provide that necessary oversight while not slowing down the process, and thus allowing the FTC to be agile and responsive to changing technological conditions and privacy harms. Of course, neither of these enforcement pieces of the puzzle can be resolved without determining how the federal law will interact with state law and other areas of federal law. We believe in strong preemption to avoid that patchwork of laws across all 50 states. But we recognize the authority of the states as well. So for this reason, we've identified some carve-outs where a state could continue to have authority. At the state level, this includes areas of traditional state authority and emerging areas, such as laws governing specific relationships or perhaps even civil rights laws. Indeed, we also believe in a role for state attorneys general or similar entities which are part of a robust enforcement regime. At the federal level, we believe that multiple existing frameworks should not be implicated by a new federal privacy law, including the Gramm-Leach-Bliley Act and the Health Insurance Portability and Accountability Act. Impacting these would result in large compliance costs and could subject more specific data to broader provisions. The substance of our recommendations is important, but we believe that the way they're presented is equally as important. So we intentionally present our information differently than standard academic and think tank products. Our goal is to provide key staffers and members an easy reference and guide on the toughest issues that national legislation has faced, and to provide consensus recommendations for resolving them. As we continue to finalize those recommendations, we believe that we have to capitalize on these patterns, continuing the work on this privacy legislation. Essentially, now is not the time to give up. We would be happy to meet with other interested groups to build on these consensus efforts. So now I'd love to transition it back over to Tatyana for the panel.
Thanks so much, Lauren, and thank you, Cory. I think we're all excited to see where this project continues and the impact legislation debate. So now I turn to our main program with our distinguished panel of experts, which I am so pleased to introduce. Today with us, we have Dominique Shelton-Leipzig, who is the firm-wide chair of Global Data Innovation and co-chair of the Ad Tech Privacy and Data Management at Perkins Coie. Dominique is known for asking deep questions that provoke transformative answers. As the chair of Perkins Coie's Global Data Innovation Team and co-chair of Perkins Coie's Ad Tech privacy and data management practice, she focuses on privacy, data strategy, leveraging data, and avoiding litigation. She knows a lot about that because she was a litigator for 22 years. And when you need an expert, you want the person who wrote the book. Dominique's landmark book on the CCPA recently published a new edition, and she pioneered the concept of data as a pre-tangible asset in what she calls our post-data world. Dominique represented the California Chamber of Commerce in a 6-week-long negotiation with Alastair McTaggart, currently CPPA Agency Director Ashkin Sultani, and California's Senator Helzberg regarding the CCPA 2.0. She's trained over 18,000 professionals on privacy, and she's a member of the International Association of Privacy Professionals Board of Directors and a leading advocate for data ethics. Her commitment to active integrity extends to all of her work, which is why we are especially happy to have Dominique with us today and join our panel. Welcome, Dominique. We also have with us today Cameron Carey, who is the Ann R. and Andrew H. Tisch Distinguished Visiting Fellow for Governance Studies at the Center for Technology and Innovation at the Brookings Institution. Cameron is a global thought leader on privacy, artificial intelligence, and cross-border challenges in information technology. He joined Governance Studies and the Center for Technology Innovation at Brookings in December of 2013 as the first Ann R. and Andrew H. Tisch Distinguished Visiting Fellow. Previously, he served as General Counsel and Acting Secretary of the U.S. Department of Commerce, where he was a leader on a wide range of issues, including technology, trade, and economic growth and security. He continues to speak and write on these issues, focusing primarily on privacy, artificial intelligence, and international data flows, along with other digital economy issues, and obviously a well-regarded scholar on federal data security privacy legislation. And we're very excited to have him here with us today. Welcome, Cameron.
Thank you, Tatyana.
Jessica Rich is also with us today. She is of counsel at Kelly Dry and Warren, LLP. Jessica was the former director of the FTC's Bureau of Consumer Protection and focuses her practice on consumer privacy, advertising, and other consumer protection matters, including compliance with federal and state laws and advocacy in federal and state regulatory investigations. Jessica has been at the forefront of numerous consumer protection and privacy matters for decades. During her 26-year career at the FTC, she built the agency's privacy program from a small team to the signature program it remains today. Following her FTC career, she served as the Vice President for Advocacy at Consumer Reports, as an independent consultant to Privacy for America, a business coalition focused on developing a framework for federal privacy legislation, and as a distinguished fellow at Georgetown University's Institute for Technology, Law, and Policy. So thank you so much for being here today, Jessica. We welcome all of our panelists, and to get the conversation started, I'd like to ask all of you a basic question. What are the main patterns that you've seen in the federal legislation debate? And for example, do you see current attempts at passing legislation different than those in the past? And I'll pass that off to anyone.
Okay, I'll start then. Oh, Cam, you go first.
No, please go ahead, Jessica. You've been longer than that.
Happy Data Privacy Day to everyone. It's so great to be here. Big picture, we have been discussing this issue for over 22 years, and I've personally been involved in that discussion the whole time. And bills aren't getting to markup now, they're just not making it, and that's discouraging. We have hit and passed many supposed turning points over these years that should have galvanized action, which is, numerous breaches, the GDPR, the passage of state laws, Cambridge Analytica, all these things that we thought were going to be watershed moments. So that's also discouraging. However, I do think that in the last few years, and indeed recent months, we've seen some developments that are promising and that put us in a better place from which to move forward on privacy and data security legislation, if we can get Congress to focus on it again, Because right now, even though there are bills, antitrust seems to be taking up all the oxygen among the people that normally focus on privacy. So we're seeing more substantive provisions instead of just notice and choice. There's a recognition of the limitations on notice and choice. So prohibitions on discrimination and other misuses of data. We've seen, this has not been heralded as much, we've seen significant movement from the Republicans. If you look at the House Republicans' recent privacy bill, you know, the Republicans aren't where the Democrats are on the issues, but there have been big steps on substantive issues like discrimination, use limitations, what information should be covered. There has been talk about middle grounds on private right of action and preemption, in large part thanks to Cam, who is here today, who really staked out some positions on that, really good ones, identified middle grounds. There has been a coalescing around the FTC as the lead enforcer, which was in question for a little bit, for a little while, and the need of the FTC for more resources. And, but I would say that the developments in the states will drive a lot of this. So far, we have 3 state laws, and people thought that was going to drive federal legislation, but because the state laws are so similar, really, they haven't. But if we see more laws this year and they diverge significantly from California, Virginia, and Colorado, I think that could really drive federal legislation. Thank you.
Yeah, Cam or Dominique, jump in.
Sure. Well, to pick up with what Jessica said, 10 years ago at this time, we were finishing up the Obama administration's Consumer Privacy Bill of Rights, trying to, waiting to see if it was going to make it into the State of the Union address and rolling it out. I was looking for partners on Capitol Hill to work with us on legislation. And at that point, I could not find anybody. So what Jessica's described is a radically different conversation than we've seen in the past. And industry has, after opposing any kind of legislation, has broadly been supporting it. There's been a lot of good work that's been done. I am disappointed that it was, as Jessica said, that people have not been able to get the job done on Capitol Hill. They are awfully close, within, as I put it, within shouting distance of each other on a lot of issues. There's still more work to be done. What I'm encouraged about, though, is exactly what Cory talked about in his discussion, and I'm just so pleased that your interactions with stakeholders really resonate with mine. And I have been in a conversation with stakeholders for really more than a decade now, but intensively since this debate really picked up over the past 3 years. And it was really on the basis of that we, Brookings and some colleagues, developed some pragmatic solutions, exactly the kind of thing that you were talking about as needed. And what I'm struck by is what Cory said, what I've seen is that the stakeholders, industry, consumer advocates, privacy advocates are ready to come to the table. It's really what is needed is the political leadership to really, get down to the hard strokes of negotiation. People are going, lots of people are willing to move on preemption, move on private rights of action. They're not going to do that until they have to. So, we need leadership from the Hill, from the administration to make that happen.
Absolutely.
Echo exactly what Jessica and Cam were just saying. And I think there's some external forces that will help bring about some of this energy and actually turn it into action. As pointed out, what's been going on in the States. I must say, on the front lines, I'm talking to everyone here from Los Angeles. California has really been sort of a crucible of where we've seen a lot of the more forward efforts on privacy. And now we are just about to embark on our sort of web, the CCPA 2.0, and we will be putting forward the very first data protection authority ever to exist, just totally devoted to data protection in the US. So that is an impetus. On the other hand, we have 148 countries now with data protection laws, most of them enacted after the GDPR went into effect in 2018. So Cam talked about 4 years ago and 10 years ago what the atmosphere is like, but I think there's been a sort of heating up of the privacy discussion, and that has also brought awareness on the part of businesses. I represent a number of corporations, and frankly, it's the uncertainty and the sort of a patchwork that is developing around the US that is potentially worrisome. And also we've talked about snippets and snappets of privacy being incorporated into antitrust bills or social media enforcement, like what we saw with Issue's recent legislation.
Dominique, it's a little bit hard to hear you, and I want to make sure that everybody can hear you well. If you could speak up just a little bit. Okay. And to your point about California specifically, obviously, California has taken further steps than other states. So talk to us a little bit about how you see the relationship between California and what their perceptions will be as we try to get federal legislation enacted.
Well, it's interesting, especially when it comes, and I hope I'm sounding a little bit better. I brought the microphone closer. So, you know, I think in terms of the private right of action, and I'd be really interested in Cam and Jessica's point of view, but I believe that because it is supposed to be a limited private right of action in California, it was supposed to be limited to negligent data breach. That hasn't really been the way it's played out in the courts, but that was the initial intent. If something along those lines that is limited and targeted could be proposed at the federal level, I think that there would be a lot of support in California in terms of our legislators. I mean, it's also important to note that this is a very popular item in California. I think it was polling at something at 92% approval rating for privacy rights when CPRA, this sort of next gen of our privacy law, was being proposed in 2019, and it continues to poll extremely high. So it's going to be difficult for California legislators to come out and support something that is radically different. But I think the proposals that we're seeing so far have been very consistent with what we've seen in California.
So can I just add to what Dominique just said, is that you would think that because California's private right of action is relatively limited, even if in practice it's a little broader than what we all thought, and Virginia and Colorado did not enact a private right of action, that it would be easier at the federal level to reach a compromise on a narrow private right of action, because the federal law wouldn't be squashing some major private right. It would simply be replicating it, or, you know, and adding in the case of Virginia and Colorado, they don't even have one. But the irony is that because some companies are learning to live with California, Virginia, and Colorado, they've apparently been less forceful on the Hill in saying they need a federal law. I did hear that from somebody on the Hill, that they're not hearing the passion from the corporate side that there needs to be a federal preemptive law the way they have in the past, which I thought was a really, really interesting observation. And if those of you listening feel passionate about it, maybe you should make that clear on the Hill.
Well, and so That is certainly one of the biggest issues. Obviously, I think we've all talked about, Cam, I know in your report on bridging the gap, you also proposed sort of a limited private right of action with some guardrails, including a right to recourse. That's something similar to what we're hearing from stakeholders. Can you talk a little bit more about some of those guardrails and how you've seen the debate transition over the course of the last couple of years since you released your report on some of the guardrails we can put around PRA to make it palatable and as part of a broader package, pass it in federal legislation?
Sure. Thanks, Tatyana. I mean, yeah, essentially this was a tiered approach, like a lot of things that we recommended to sort of scale up depending on the circumstances. And the focus of a private right of action was on things that are highly offensive to a reasonable person. That's been the common law standard, under which we've protected invasions of privacy as a tort at the state level for many years in this country. In addition to that, discrimination, financial harm, so that there's the opportunity to get individual redress for things like revenge porn, a data breach that actually causes identity theft or financial injury, other kinds of things, and discrimination based on the use of personal information. All of these are things that we traditionally recognize and compensate. So that's the core. For other things, there should be what we proposed is a higher standard of liability. So no statutory damages, and requirement of knowing and willful violations for things that are more technical violations. So you don't have gotcha lawsuits if under a right of access, a right of correction, a company doesn't move fast enough. And then importing from securities law some of the sort of speed bumps that exist on class actions. So the idea is to focus on those things that are clearly well-established kinds of damage, and filter out the damage multipliers on other kinds of violations. What's been the reaction? It's been positively received. Look, we saw in hearings last September, the 21st Century Coalition come in, and this is a coalition of internet service providers and communications companies say, yeah, we are open to a private right of action with guardrails sort of along the lines that we've discussed. And there have been a number of companies that said, yeah, redress is needed. Some privately, a few publicly, but a number of organizations have had those kinds of conversations. And this is what I mean about stakeholders kind of being ready to have the discussions, to have the hard negotiations. I think, while in Congress, things are kind of about where they were at the time we issued our report in 2020. I think stakeholders have moved forward. They're ready to sit down and do business.
Yeah, I would love to see that. And obviously, so the way we see the way we see PRA is as one part of a larger enforcement mechanism, right? And Jessica, to you, having been at the FTC, I think you generally support one of the things that we found, which is that if we can get the broader, better resources to the FTC, including technologists and psychologists and just more people, broader than the 50 they have now, right? We're thinking somewhere around 500. might be might create a situation where that enforcement mechanism is sufficient?
Well, my mantra has been that if the law is strong enough in its provisions, in terms of protecting consumers, plus the FTC is given adequate enforcement authority and resources, plus the state AGs can enforce, that maybe you're making it less necessary to have a private right of action. That's been my position, and that's mostly true. But there, one of the counter arguments is, well, even if there's really robust enforcement and a lot of resources, some consumers are going to slip through the cracks because they're not going to be captured in either a federal or a state action, and therefore they personally are not going to be vindicated. I think CAM's middle ground provides some answers to that if people would be willing to really consider them, and some of them could be quite narrow, especially when, given what I was saying about state laws not even having a private right of action. But another solution that I'm seeing in some legislation is that in addition to state AGs being able to enforce the law, other agencies in the state with jurisdiction over privacy could enforce the law, which could include more local type agencies. And as long as they're enforcing the same law with the same standards, that could even cover the field even more without need for a private right of action.
What say you, Dominique?
I agree with that. If you look at what's gone on in Europe, and I know that there are some consumer advocates that are critical of the enforcement of the GDPR, but taking a step back, it's over $1 billion, it's estimated, that has been assessed by European data protection authorities for alleged violations of GDPR. And just the threat of having an investigation and the press associated with it has certainly had an impact on the importance that companies take in paying attention to that law. So I think that a private right of action is not necessarily needed in order to have the impact. And when you look at Europe, which doesn't have the culture of class actions that we have in the US, we've seen GDPR be enormously effective around the globe.
So speaking of the globe and cross-border data flows, I wanted to see your thoughts on how the legislation would help to address issues with some of the issues around cross-border data transfers, especially after the fallout of Schrems 2.
Yeah, this is, and I'll just jump in, and I'd love to hear Cam and Jessica, but to my mind, this is one of the strongest drivers, or should be one of the strongest drivers for us coming together around a federal privacy law. It's just going to become essential. I read something that the top GDP countries all have sort of omnibus privacy and data security laws similar to GDPR, except for number one, which is the US. We really are being left behind, and it is creating delays and time constraints and problems for companies that are doing business internationally. And the more and more we see, as we talked about, other jurisdictions like the Middle East and Africa creating data protection laws that are mirroring the EU, we can see more and more cross-border issues perhaps replicating across the globe.
Yeah, that's absolutely right. I mean, the United States, as Dominique said, has become the outlier, among all the major economies. Tatyana, you mentioned China. We are handing China a talking point. What about the United States, despite all of the pervasive government control that they have around information? It hurts the democracy agenda. It hurts trade. It hurts trust in American companies. We need to address it, and that's a factor in the European Court of Justice Schrems decision. The perception that the U.S. is a Wild West of data. So comprehensive privacy legislation isn't going to solve all of the issues because, intelligence collection is at the heart of it. But it certainly, as a European official put it to me, it's background music to the discussion. And it affects politically how Europeans see the United States, the latitude that the European Commission has to come to a reasonable decision here that it can defend, not just in the court, but defend politically with members of parliament, with the member states across the European Union.
I want to put a pin in, though, what Cam said about it's not going to solve all of the problems. I do think it's important to the to resolving some of our international issues, but the focus of both Schrem's decisions was around the ability of national security to get information from companies, and that hasn't been solved. And in fact, just the last few days, I've seen these reports, and there was more on this, last year as well from the Wall Street Journal about the government buying information from data brokers and doing that to get around the Privacy Act. I think there has to be some steps taken on the national security issues as well. Now, a commercial law would help for all the background issues and to shore up that piece of it. It'll also help because there at least would have to be provisions in it dealing with companies sharing with law enforcement and for national security purposes. That would have to be in the law to provide guidance. So at least there would be some visibility around it. But our national security people are going to have to figure out what concessions they can make there to provide more accountability for data that they collect.
Absolutely. And so, we've talked about some of these other issues that will need to be addressed, or that will have to be involved in the federal debate. And we've obviously raised 3: preemption, PRA, and FTC rulemaking. But I know that there are others, and there are others that we want to discuss in our future research, but wanted to open it up to you to kind of get a sense of what you think is what other areas need to be included in the federal legislation.
Sure, and happy to jump in on that. Look, the preemption and private right of action issues are certainly an important part of the debate, but I've described them as endgame issues, things that when those negotiations happen and people really have to sit down to the table and make the hard choices, they will make those hard choices. And I hope that the work that you're doing and the work that we've done and others like Future Privacy Forum to help to define the contours of those choices. I think there are some other issues that still need to be addressed. We've talked a little bit about the civil rights issue. And I think, we've reached a point where I think there is some consensus that there needs to be a provision in a federal privacy law that bans the use of personal information to discriminate in ways that we prohibit on race, sex, et cetera, protected categories. There's still work to be done to define exactly what the terms of that should be and what the remedies should be. And the other critical area, I think, is putting boundaries around the collection, use, and sharing of data. If we're going to move away from a notice and consent system, Congress has to say, set some rules for what data could be collected for what uses, so that you don't just sign everything away with a consent. Senator Blackburn talked about that people need to be able to trust that their data is being used appropriately. I think Congress needs to spell that out, and in a way that establishes a nexus between the uses and the sharing of the data and the services and the relationship that lead to the collection. We need to leave some play in there for innovation, for new uses, but within reasonable boundaries. I think you do those things. You have a law with boundaries on collection and use that has civil rights protections and has some kind of individual redress. You do much better than any of the state laws. I think that makes the preemption argument a lot easier. You also, with a discrimination provision, and potentially with rules on some rules on algorithmic transparency and accountability, you do go further than GDPR. So we put the U.S. in a position, where it can be a leader internationally instead of an outlier.
I would love to add, rather than, I agree with everything Cam said, and he and I have been talking about these issues for years, so I'm not surprised. But pulling back a little, I think a big driver here is that any federal legislation has to be at least as strong as the laws we have today. And one of the biggest obstacles is the fear that there's going to be weak federal legislation that preempts the states and thus weakens the bar that we have now. So one of the big drivers is what are the protections we have in place now? Well, they're scattered and there's gaps. So federal legislation already has that, would have that advantage. But I think people are looking to make sure that federal legislation is at least as strong as what we have in place. And I would also add that given that Congress has so struggled with how it can come together on this issue, I don't think that we should abandon the idea that Congress pass data security legislation on its own. I think it would have meaning without privacy. It's hard for privacy legislation to have a lot of meaning without data security, but I think the other way around, securing your systems would go at a huge distance to protect, advance data protection in this country. It's an area where there's a lot more consensus than in privacy, and it could lay the groundwork for compromises on some of the tough issues and lay the groundwork for additional privacy legislation later. So I don't think that should be off the table.
Okay. Dominique?
Yeah, I'm really interested in what Cam and Jessica just said, and with respect to what might be salient in Congress right now and that might actually have traction in this sort of social justice moment that we're in. The idea of incorporating or including the civil rights, the social issues inside the privacy bill might actually bring the parties together and bring attention on this issue and make it one that is not so tactical or antiseptic for purposes of facilitating the 7.1 trillion in commerce that's going back and forth between the US and Europe, but rather getting to the humanity of the moment that we're in. So I think that is a very interesting approach, and one that actually might grab hearts and minds. The second thing that I would say that I think is really important with respect to not going backwards in making the federal law at least as strong as what is existing at the states. At the state level, I just think it's just so important to understand that for those states that have crossed the Rubicon and actually introduced and passed legislation, the popularity of that legislation is such that it will be, to Jessica's point, very difficult to propose something that is less than. So I'm really excited for the momentum. And I will say, certain companies, not to call out ones or others, but I noticed Microsoft has been very active, Julie Brill, very active on these issues of calling for federal privacy law.
Yeah, I want to add something to what Dominique said, because I think the emergence of civil rights as a significant issue here is an important one, and certainly resonates with the administration's equity agenda, and I think has brought additional players to the table in this discussion. And I mentioned that there is a certain amount of consensus on doing this. I mean, the Republican bills have civil rights provisions in them. I've talked to people in the civil rights community who like the provision that the House Energy and Commerce Republicans came up with. It was regarded as a pretty good starting point. I think there's a lot more, though, that on the industry side that needs to be done. I think the privacy advocates, the consumer advocates have all, I think, thought a lot about this because it expands their coalition. I don't think, frankly, that industry has thought enough concretely about it. I think there's buy-in. In principle, yeah, we're against discrimination. We think that ought to be part of the bill. But what exactly that ought to look like, there's work to be done.
And it's interesting when you look at, outside of the actual policymaking, what's going on sort of in industry with boots on the ground. They're looking at algorithmic fairness, data ethics globally because of the legislation that's being proposed in the EU and in other jurisdictions. They're also looking at brand value, trust concepts. And so you see a number of the companies that just decided that they will not be selling certain surveillance technology until the algorithmic issues could be addressed in terms of fairness and bias. And then I was also excited to see Ken Chenault's group, the Data and Trust Alliance, come forward with so many signatories, Walmart, et cetera, from retail and other places, coming together around the idea about civil rights and algorithmic fairness and bias and privacy. So I think that is a topic that could have a lot of traction, as could antitrust. That's another area that I see.
Dominic, I think the goodwill is there. We got a lot of attention to algorithmic fairness and algorithmic ethics. It hasn't been related to sort of the language of civil rights laws. So, where does this fit with public accommodations, advertising? What do you do with disparate impact? There's some concrete questions that need to be addressed and relate back to all that good work.
But I think it's very significant, and this goes to your earlier point when looking back, a decade ago, Cam, when even just a couple of years ago, when the idea of including anti-discrimination provisions, civil rights provisions in a privacy law came up, people were like, that is going to derail it. That just doesn't belong in a privacy law. People who weren't pro-discrimination, and now that whole narrative has changed, and you see it now as a basic in every bill. So that's huge progress.
Yep.
The other thing I think is kind of interesting, and Jessica, I would be interested in your point of view, and Cam and Tatyana, is just this overlap between antitrust and privacy that we're hearing, Senator Klobuchar's hearings in September. And then I just was listening to Lena Khan's Sway episode on Sway podcast with Kara Swisher last week. And in an antitrust related program, she spent quite a lot of time talking about privacy. So it might be that antitrust is what ends up motivating people to do the federal privacy law.
Well, it's really interesting because first, Khan has talked about that a lot, but so far we don't really know what she means, and we haven't seen a specific example of where she's reconciled antitrust and privacy in a case. Meanwhile, you have all these lawsuits going forward, antitrust lawsuits that are trying to have the platforms open up their platforms, even from like state AGs who simultaneously in other areas are supporting closing off access to data. And in Klobuchar's privacy bill, antitrust bill, which was criticized because which is an attempt to make the platforms open up so that they're not favoring their own products and services, and other companies have access to the consumers on the platforms. Those privacy provisions were tacked on at the last minute, and they're terrible because they're not thought through, and it's gonna, and you know, not that I just buy all the press releases from companies saying, oh, this is gonna create data security problems, but I looked at it myself and I think it is. So somewhere somebody's going to have to take a very sophisticated look at the tension between antitrust and privacy and really try to tease this out in a meaningful way. And so far, I haven't seen it.
So
Look, this is the reason why we need a comprehensive privacy law. You know, right now there is this tension between antitrust and privacy, and some of that is because of what Google is doing on its platforms to reduce ad tracking. You know, Apple's privacy controls and its impact on apps in the App Store. But you know, right now, they're kind of the only game in town as far as privacy. If we had some defined boundaries on data collection, use, and sharing, then a lot of the rationale for what they're doing goes away, and you focus on what the competitive issues are.
yeah,
I agree that we need a privacy law, and then the antitrust can work in tandem with it, rather than, you know, them just butting up against each other.
Yep.
Yeah, so the question, I guess, and I've written about my cybersecurity concerns in those antitrust bills, but also the privacy concerns, that if the privacy piece is addressed through an antitrust piece of legislation, does it create sort of a piecemeal approach that would not necessarily address all of the privacy concerns, right? And then leave us in a worse place than we are today?
Yeah, absolutely. I was just wondering if the interest around antitrust might be an impetus for the federal privacy law to get done, because it's being addressed sort of in smitters and smatters in these other places. And maybe this could be something that brings people together.
So that's a great question. I've actually heard people suggest that if, and I don't know what will happen, obviously no one has a crystal ball, but if the antitrust bill fails, that then the Congress will be looking for something to replace, and still a piece of legislation to address some of these concerns with big tech. And what are your thoughts on whether a privacy bill is that something?
It should be. Yes, yes, yes.
That's what I think too.
It would address.
Get you to be one of the senators.
And it would address so many of the things we've been talking about in antitrust. Not all of it, but it would at least partially address the power of the platforms, the disproportionate power that has been created through the amassing and controlling access to information. It could address, for all the reasons we talked about, discrimination, which is a huge issue. It could address data misuse that leads to harm and fraud. It could address all of the harms we've been seeing, like that Frances Haugen with teens and the manipulation of teens emotionally using their very personalized data and profiles. So there's so many ways in which privacy could be the issue of the moment that would solve a lot of these ills, not just antitrust.
Yeah, amen to that, and you know, my hats are off to Senator Klobuchar and Senator Grassley for doing job of legislating and getting a bill marked up. You know, the privacy legislation has really seen, I think, a lot of classic legislating that senators and congressmen have learned a lot in those various privacy hearings. It's come a long way. There's, I think, a lot of sophistication that people have developed on privacy issues. I hope that Senator Cantwell and Senator Wicker can get together and do the same thing and tee something up, or in the House, as the case may be. They're continuing to try to come up with something bipartisan.
Absolutely.
And I also just think the great news is that a lot of businesses want this certainty as well. It's this uneven landscape and uncertainty about what is around the corner that is worrisome. So if something could be done on the federal privacy law and that perspective, at least the rules of the road would be known. And you see so many CEOs now calling out for legislation so that they know what the guardrails are.
Do you all get the sense that that message is getting across on the Hill?
Not from at least some of the remarks I've heard, that companies don't seem to be clamoring as much as they were. Although, you know, we recently did see the letter from the chamber that went to the Hill. But it feels like companies are waiting to see what happens.
Cam, what are your thoughts?
Yeah, my sense is similar. I think you know, there have been distractions. I mean, certainly for many companies, the broadband bill was significant. Other things that have been pending in the infrastructure legislation or Build Back Better. So that's I think where a lot of the lobbying energy has been going. And of course on antitrust. So, you know, people again are kind of waiting until they have to do something to do something.
One thing that I think people have not thought about. So everyone's talking about, oh, the Democrats don't have a chance. You know, we're running out of time for the Democrats to do something on privacy. Well, I don't have any inside knowledge, but I think it's very possible that if the Republicans take Congress, the Republicans will do something on privacy. And it won't have everything in it that the Democrats want. But, you know, increasingly as companies are anxious about the states passing laws, and, you know, you hear Marsha Blackburn strongly endorsing a national standard, I think it could happen under the leadership of the Republicans, and that should create more motivation right now for the Democrats to provide some leadership now if they have a vision for how they want this to go. That's
a great point. So our conversation so far has shown how far-reaching this debate is, and it also opens up more perspectives for solutions. For example, could we be drawing from good examples in existing legislation for particular provisions that you would like to see copies of in federal law?
I think that's a great way to start off finding consensus where things have already been agreed to, and the appetite is already there. To the extent we can build off of shared understandings and shared sort of shared commitments, I think that's the best way to move forward and maybe try to do something before midterm elections.
Yeah, it's always helpful to have language that you can point to that's been approved before. I think the problem here is that the data world has changed so much that there is a lot that has to be done that's new. And I think some of those key issues about, most of the laws that we have, particularly the more recent ones, it's actually different with the Federal Privacy Act, really are focused on sort of the notice and choice model, and everybody knows that's broken. That choice is a fiction. We do need to write some new provisions. Civil rights is taking certainly what's there in civil rights laws, but applying it to personal information. So that's a little bit new.
Everything that Cam and Dominique said, I think is very insightful. And but I want to add that as much as I support and have supported for 22 years a broad-based privacy and data security law, it is instructive that if you look at the data security provisions in most draft legislation and even in existing legislation that's been passed, it's pretty similar. So again, one option that would advance data protection in this country would be to pass a standalone data security law as a start, and it would be huge.
Dominique, what are your thoughts on that?
I think that, I tend to agree. I think that there's such attention going on, especially in the boardrooms around the US with respect to the rise in cyber issues, ransomware attacks, not the least of which is that, but just a heightened awareness around cybersecurity, especially as we're in the pandemic. So that might be an area where you would be able to get, as Jessica suggests, a lot more sort of business input and business, I guess, energy around this, because the cyber issues and the ransomware attacks are almost on every major company's list of things that the board and the officers need to pay attention to.
To play devil's advocate, so given the difficulty of getting legislation passed, if we give up privacy, the privacy portion of this law now, what's the likelihood of getting it in later?
I think we've been gaming that for years, and it didn't turn out so well. We've been holding out, and I would love to get the broad law, but I don't think you can game that out, and we haven't won that bet yet. So I'll take what I can get, and data security is so significant. It's not a slice. It's very significant.
Yeah, my instincts are the same as yours, Tatyana. I want to hold out for data privacy and not do this piecemeal. But I recognize a couple of things. One is we saw that just data breach laws, done on a state-by-state basis, had a positive impact on privacy protection, because people had to think about, what are we collecting, what are we doing with it, how are we going to take care of it, and data security law would go a step beyond that. And I resisted in government some efforts to sort of try to legislate that, but I think things have evolved, both in terms of the threat landscape, but I think a broader understanding of some basic best practices in cybersecurity that now we do need to establish that baseline. I'd rather see it in data security provisions in privacy legislation, but you know, I'll concede there's something to what Jessica is saying.
All
Yeah,
right. Well,
that might be a way to push the conversation forward, to include maybe some of those sort of push on or emphasize the privacy in the privacy bill, the cyber components, and really kind of build it up even with the privacy in it as talking points focusing on the data security. And maybe that'd be one way to get everything in one bill still.
all right. Well, on that note, I want to thank you all again for joining us for this very interesting discussion. Thank you so much to all of our panelists, as well as Senator Wyden and Senator Blackburn for participating in our event, and to Lauren Zabierek and to Cory Simpson, my partners in this project, and the whole Our Street team for helping set this up. Thank you so much. Happy Data Privacy Day, and I hope that we can see some federal legislation in the future.
Thank you.
Thank you.
Thank you so much. Thanks for inviting us.